Yes. Good morning, dear student. I hope you are all fine. And I hope you are getting ready for the exams. Yes, exams. I say that deliberately. You don't wait until January to be getting ready for the exams. You get ready for the exams now. This is the time to begin to get ready for the exams. So that when you come back in January, because when you come back in January, you are likely going to you are going to have a test. Not likely, you are going to have a test in January. So that means you must be getting ready now and you must be preparing. Okay, so I sent you a message that you should listen to the lecture on the defense of compulsion. And then after that, part of that video also includes the defense of extraordinary emergency and the defense of the plea of provocation as a defense to the offense of assault. And I said also that you should listen to the lecture on attempts. So those are the topics that are up for discussion today. So I believe we can start straight away. So I will give the first 30 minutes or thereabout to those who wants to ask a question on the defense of compulsion, the defense of extraordinary emergency, and the plea of provocation as a defense to the offense of assault. So, like we normally do, if you have a question, then you will raise your hand, your digital hand, that is, and then I will enable you to ask your question, and then we can take it on from there. So, Tayo A. Adekunle, you can unmute and ask your question.
Good morning, Prof. Morning, sir.
Good morning. How are you doing?
Very well, sir. Fine, sir. My question is in the area of the defense of extraordinary emergency.
Yes.
You cited an Australian case of Counsel and Glynn, which interpreted a somewhat similar provision. So I want to say that the principles governing that defense seems to me to be maybe impossible to happen in reality. And because from what I understand from the video and the reading I did from your text, it seems that the kind of emergency that the defense contemplates may not really happen in reality. So I want you to shed more light on it, sir.
Well, I think I gave the example. Of somebody who is driving. You are driving your car on a busy road, and having regard to the volume of traffic and pedestrians walking on the road at that time, the speed at which you are driving can be said to be reasonable in the circumstances. And a little toddler suddenly runs across the road. Now, at that time, all you can do is to press your brake and then maybe swerve off away from the oncoming child with a view to avoid knocking the child down. Now, if in the process of doing that, you knock down somebody else, or in the process of doing that, you suddenly swerve off the road and then you climb an embankment and you hit somebody, sitting down a little bit away from the road. That is a situation of extraordinary emergency. And within the circumstances, what you did, is what every other normal human being would do in the circumstances. Okay, so that is one example in which the defense would apply. And like I said, the defense will not apply where the facts of the case would support other pleas that are recognized in the law, such as the plea of self-defense, for example. So that is one case in which I can imagine that defense may apply. Okay, so I don't think it is correct to say that there is no circumstance in which the defense will apply. Okay, so that's my response to that. All right. Grace Nachi, on mute.
Good morning, sir.
How are you, Grace?
I'm fine, thank you, sir. So my question has to do with the defense of compulsion. In your video, you made it clear that under the criminal code, the defense does not extend to where it's another person's life that is threatened, and or it must be the person's own life that must be at threat. And like I just said, the provision is a bit unfair, right? So if in a situation something like that occurs, would there be another defense that will avail the person to kind of negate or reduce the unfairness of the situation?
Well, there's no other defense that is known to law that may apply in that case. The only thing that the court will consider is when it comes to punishment. The court may look at that as a circumstance that will reveal the gravity of the punishment. In law, when the law says that if A takes the property of B without B's consent, with intent to fraudulently deprive B of his property, A is liable to 3 years imprisonment. What that means is that A is liable to a maximum of 3 years imprisonment. But the court will have to consider a set of factors to determine whether A is liable to the maximum. Because when the law says 3 years imprisonment, that 3 years imprisonment is the maximum. That means the court can impose a sentence as low as a sentence of 1 day imprisonment, or fine, or a non-custodial sentence. So in that example, the defense of compulsion does not excuse it because it does not apply in relation to a threat made to another. So in that case, the court will look at that as a circumstance that will mitigate or reduce the amount of punishment because the offender did not go about intending to commit the offense for his own reason. He was only made to commit the offense because somebody, there was a threat, to another. So that's the response to that.
Okay, thank you.
Collins Akube, you can unmute. Collins, you can unmute.
Okay. Good morning, sir.
How are you? Good morning.
Yeah, my question actually borders on the question the last speaker was talking about, but I'm taking it from a different perspective. Like you rightly said, it's left to the discretion of the judge to now put into account this the situation of the case. But looking at it from the Nigeria perspective, obviously the application of that principle is very narrow. But could it not be said that, okay, pleading the principle of love and affection as espoused by Lord Mansfield, which says that, okay, because of the love that exists between family members, it can reasonably be understood that, okay, if like a father who perhaps his son has been threatened, so can he not now say, okay, based on that trait and the love that exists between them, that principle will not be able to be wide enough to like accept that situation, especially here in Nigeria. Of course, in the UK, that is a different case.
Yeah, colleagues, thank you very much. What you are saying is justification for amending the defense to excuse grievous harm threatened to another. But the law as it is in Nigeria today still remains as we have explained it. Yes, just like the law also allows you to aid another person to defend himself. The same rationale for the law allowing you to aid another person to defend himself to also apply in this instance. Okay? Where, you know, somebody is threatening harm to your loved one and is trying to do harm to your loved one and is compelling you to do something in return. Otherwise, it will do harm to your loved one. It is the same reasoning, and that's why we said that this is an issue that calls for reform in Nigerian criminal law to reflect natural human disposition to protect persons to whom we are closely related or feel a sense of obligation. So what you have said constitute reasons that will justify amending the provisions of the law. Yes, any other question? Any other question on compulsion, extraordinary emergency, or provocation as a defense to the offense of assault? Nwogba Samuel, or mute.
Good morning, sir.
How are you doing, Nwogba?
I'm very fine, sir. Yeah, I have a question with respect to the defense of provocation. So the first is, I want to know the significance of the requirement which is provided for in the section 284 of the Criminal Code, which has the assertion on the sudden and therefore and before the time for his passion is about to cool. I want to really know the major significance with respect to that, because the court will have to determine who an ordinary person is and how the person lost self-control at the same time of circumstances. I want to know what is the major legal significance of that requirement to determine the suddenness and, you know, before there is time for his passion to cool. Because I was like, is the code or this legal perspective provided an avenue to justify the act of such provocation? Because some persons, if this should be a base or a legal base to justifying their act, will have to, on a slight provocation, carry an act which is, you know, somehow to terminating a person's life. So that is my first question.
Okay, let me answer that one first. Now, the requirement of sudden provocation is to qualify the right, or is to qualify the situations in which the plea of provocation will apply. Okay, now you need to remember that the plea of provocation is a defense that recognizes human frailties in the sense that it recognizes that as humans, we may sometimes lose our cool. We may sometimes lose the ability to control our actions because of a provocative act of another. Maybe because of an insult or a grave insult that somebody has done to us, we lose our control. And when we lose control like that, we commit an offense. In the case of provocation as a defense to assault, and you now assault the person, then you may be able to rely on the plea of provocation as a defense to that assault. But you must have reacted, suddenly and in the heat of the moment. If somebody provokes you now, and immediately you get annoyed and you react, and maybe you slap the person's face, you slapped the person's face, that may provide you a defense for the charge of assault. Of course, there are other requirements that your response must be proportionate in the circumstances and so on and so forth. But the requirement of suddenness there is to limit the scope of the plea. If you had time for your passion to cool, somebody annoyed you now, and you got annoyed immediately and you reacted, yes, the plea of provocation may apply. But the person annoyed you, and you got annoyed, and somehow your annoyance cooled off. And then the following day, you now remember that this guy provoked me yesterday, and now I'm going to deal with him. You will not have a defense because the provocation was no longer, and your response was no longer sudden in the heat of the moment. You've had time to cool. You've had time to regain your composure. You've had time to regain control of your emotions. Therefore, the law will take your attack the following day or several hours after the event as a revenge, thereby entitling you from relying on provocation. The same principle applies whether it is provocation as a defense to assault or provocation as a defense to a charge of murder. So you can go ahead with your second question.
Yes, okay. Thank you. So just on the second base of the question, I want to know if provocation must be in line with some elements of force. So is there any ground whereby this provocation covers some kind of emotional triggers which has nothing to do with force? Let me just paint a scenario whereby somebody raises the question of, yes, this person provoked me emotionally, and because of such kind of provocation I had to carry the act. Because we once had a story whereby a young man who attempted to rape a girl of 12 or so, was saying that it wasn't his fault, that the girl walked into his room and found him and decided to pull off some acts. He just got up under that influence. He thought he was triggered to do what he did, although he was actually sanctioned through the judges of the law. I want to know, is he only on some kind of element of force whereby the plea of provocation can avail the person, or does it cover other areas?
Well, provocation does not have to, it does not have to arise from a violent act alone. If you look at the definition of provocation under section 283 of the Criminal Code, it says the term provocation used with reference to an offense of which an assault is an element include any wrongful act or insult of such a nature as to be likely, when done to another person or in the presence of another person, to another person who is under his immediate care, or to whom he stands in a conjugal, parental, filial, or fraternal relation, or in the relation of master or servant, to deprive him of the power of self-control. So the important thing is that somebody has done a wrongful act or insult of such a nature as to deprive a person of the power of self-control. So it may not be that the person did something that is violent or forceful. No. Provocation can be triggered by anything that constitutes, in fact, the code says any wrongful act or insult. Insult. Anything that is a wrongful act or insult. You know, assuming, the Vice Chancellor is making, she's addressing, a group of students, maybe at the auditorium. And a student climbs the podium and moves towards her and grab the microphone from her and say, "What are you saying, you this stupid woman? Are you the only female professor that will be the? Are you the only female professor that will be a vice chancellor in the university in Nigeria? After all, Professor Grace Alele Williams was the first, female vice chancellor in Nigeria. That is an insult. Although that, well, let's even assume that grabbing the microphone could be a bit forceful. Let's assume that it's just a verbal insult. The student just approached, climbed the podium and start raining abuse on her. Are you the only woman? There are women, there are other women who are more competent and, more deserving than you. You got there because you were able to manipulate yourself. All kinds of, unprintable things. That is an insult. So if the person insulted in that kind of a situation responded with a slap on the face of the, on the face of the person offering the insult, the person will have a defense of provocation to a charge of assault. So it need not be, the trigger need not be a violent or a forceful act. The law says any wrongful act or insult is sufficient. So that's why, for instance, if a man catches his wife with another man on his matrimonial bed having sexual intercourse, that is enough to trigger the laws of self-control. Or it could also be a woman who finds the husband, having an affair on their matrimonial bed. That is a wrongful act or insult that can trigger a violent reaction. So the trigger need not only be something that is forceful or violent.
Okay, sir. Thank you. My next question is, how would the defense of compulsion apply in scenarios where the threat is made remotely, such as maybe through a phone call or online communication? So I want to know, how would the defense of compulsion apply in such scenarios?
I was going to withdraw later.
Sorry, you can mute your device. I can hear some background noise.
Okay. I still have more questions.
A threat to the victim is not able to escape. Something that you are trapped, and there's a threat on your person, and you're not able to escape. So it depends on the. In fact, I remember that I gave an example in my book, a situation in which somebody received a phone call that a time bomb had been sent to detonate in his office in 15 minutes, and is asked by the person threatening him to provide a thing that were put in for her bank account. And the person threatening him, demonstrated his ability to remotely detonate a bomb playing in a car at 500 meters from the office of the man being threatened. And as the man was looking at the window of his office, he saw that a bomb was remotely detonated. I mean, you will be an angel for you not to be afraid if somebody calls you and makes that. Now, so in that kind of a situation, it depends the way the code is drafted now, it talks about immediate death. And, you know, it kind of gives the impression that the person offering the threat must be actually and physically present. But I believe that in this kind of a scenario, one can say that, you know, the victim in this circumstance should be entitled to rely on the plea, because even though the person giving the threat may not be actually present, but the way the threat is and the way the threat is given, the threat is so real, and it is a reality. It is a process. It is the sense of being trapped that the victim experiences that provides a basis for the defense. So that's my answer to that. Okay, so let me allow Olatunji on mute.
Good morning, sir. Please, can you hear me,
Good morning.
sir?
I can, loud and clear.
So my question is with respect to the defense of extraordinary emergency. So some time ago, I was reading a scenario where a doctor was to attend to a patient that was in a very bad condition. She was rushed in from a ghastly accident, and as a result, it was in an emergency situation, so he just had to do something, and as what he did actually worsened the condition of the patient. So my question is basically that this defense of extraordinary emergency, is there an exclusion given to professionals like doctors or those that are meant to be a professional in their field? So is it that in all extraordinary emergencies and they act, they can bring up this defense? Or because we can say that, wait, you are a professional in this field, this should not be an emergency to you? Or is it something like that that applies in criminal law, sir? Did you hear my question,
Well,
sir?
Yeah, I had your question, but let me try to make sense of it. Now, in the example that you have given, somebody had an accident and
Yes, sir.
he needs immediate surgery. And maybe he's even in a coma. He's not even in a position to give his consent to the surgery. The doctor is allowed to go ahead to do all he can in an attempt to save the life of the patient. But if in the process the patient dies, so long as it is not a case of the doctor being grossly negligent in the manner of treating the patient, and that results in death. If that is not the scenario, hold on. If that is not the scenario, then the doctor is not liable in any way. Because, I mean, we must realize that patients often die in the process of surgery, not because the doctor is incompetent, but maybe because the body of the patient is not able to withstand the trauma of the operation. So that is not an instance in which you can talk about the defense of extraordinary emergency. Okay? In that kind of emergency, the doctor will be authorized to circumvent the other rule, the normal rule, which requires him to get the consent of the patient before treatment. Because in this instance, the patient is not in a position to be able to consent because the patient is in a coma. So I don't know whether that answers your question or whether you want to recalibrate the question.
Okay, somewhat. It was like a scenario that was painted in a seminar that I was listening to. It was that the lady was rushed in a very bad condition, actually.
Yeah.
So the doctor did something immediately. It wasn't even a surgery-related situation. He applied some medications immediately that actually worsened the lady's condition.
Yes.
So when the family came out, they were like, who did this? How could someone have done this? He's meant to be a professional and all of this stuff. Then he said that he acted because it required emergency approach, and he didn't really know what he was doing at that point. He was in shock as to how someone could be in that bad condition. So the doctor was trying to raise the defense of emergency in that instance. The family were like, oh,
what I can say is this. The test of whether the doctor will be liable for the death is whether what he did was reasonable and proper in the circumstances, and whether that is what an ordinarily reasonably competent doctor would have done. If what he did was what was proper in the circumstance and what a reasonably qualified doctor would have done, even if that is what caused the death, the doctor is not liable. Because sometimes when you apply a medical treatment to a patient, which is a normal medical treatment that you can apply having regard to the situation of emergency. You know, normally before doctors treat you, they will ask you to go for this test. When you do that test, they will ask you to go for another test. Sometimes they will ask you to go and repeat a test in another laboratory to be sure that the test was properly done before they now make a prescription. But in the case of emergency, you'll not be able to do all that. The doctor responds on the spot of the moment, applies the kind of treatment he thinks is proper and reasonable in the circumstances. And if the patient's body cannot withstand that kind of treatment and the patient dies, you cannot say that the doctor is liable because he had applied the kind of treatment that is proper and reasonable in the circumstances and the kind of treatment that a reasonably qualified doctor would have applied in that circumstances. So that is what will govern whether the doctor is liable or not. Okay? Omole Emmanuel. You cannot mute.
Good morning, sir.
Morning.
Good morning, sir. Yes, sir. So my question is on compulsion, defense of compulsion, under section 32(4) of the Criminal Code. So that provision allows the accused to use such force as necessary to prevent himself from immediate death or grievous bodily harm. But
Yes.
when the next paragraph after that subsection, it says that the act does not extend to an offense that constitutes death or grievous bodily harm. So I'm thinking, I'm not too pleased with the provision since it's like more like appropriating and reprobating. Someone is under fear of immediate death, and you're saying that he can do anything, but he must not cause, grievous bodily harm or even death or grievous bodily harm to the person. So let's say, for instance, now I'm in the north. Yeah. Yes, sir. So let's say, for instance, I'm in the north and I'm walking on the street. Then I enter a corner. Okay, sir.
It's not to the person of the person threatening him. It's to the person of another. Okay?
Sir, please can you repeat it, sir? I couldn't hear.
Now, let me read the provision so that you get the point clearly. A person is responsible for an act of omission if it's done for to do an act in order to save itself of immediate death or grievous bodily harm, to be inflicted on him by some person actually present and in a position to execute the threat and believing himself unable to escape the crime of the threat of execution. But this provision does not extend to an act of omission which is punishable with death or an offense which grievous harm to the person of another. So the exclusion you are talking about is causing grievous harm or death to the person of another. You cannot rely on the defense of compulsion as an excuse for you to kill another person. Okay.
Apart from
let me illustrate. Let me illustrate with this example.
Okay.
I threaten to kill you. And the only condition in which you will escape from that, my threat to kill you, is if you kill another person. That person is my enemy. I want the person killed. But I don't want to kill him myself. And I'll say, go and kill this person. If you don't kill him, I will kill you. Now, ordinarily, you are supposed to, because the threat, you are not in a confined environment. You are supposed to report to lawful authorities. Then they will take care of the situation. But let's even assume you are in a confined environment. The person comes into your house at night or comes upon a situation where you are gathered, and he gives you a gun and say, shoot this man on the head and kill him. If you don't kill him, I'm going to kill you. And then you pick the gun and shoot the man on the head. You are liable for murder because the law cannot allow you to place a greater premium on your life over the life of another. Why would you choose to kill another person because you want to save your own life? That's the rationale. That's why it says grievous death or an offense of which grievous for the person of another. The person threatening to kill you. If you kill him, no problem. You can raise your plea of self-defense. But you cannot use the threat of that person to kill you as a justification for you killing another person. No, you cannot.
All right, sir. Thank you
So
so
does
much.
that answer the question?
Yes, sir, perfectly well, sir.
Thank you. So we'll take I'll take Onodipe and Adelaja. Then we'll move over to attempts. So Onodipe, you can unmute. Nwogba, bring down your hand. Onodipe, you can unmute.
Thank you, sir. Good morning. Can you hear me, sir?
Loud and clear.
Hello, can you hear me, sir?
I can hear you, Onodipe.
Hello.
I
Good
can
morning,
hear
sir.
you.
Can you hear me?
I can hear you unless you are not hearing me.
Okay, I can hear you now. So I have two questions. The other one is from personal experience. So let me ask the first one. It's on provocation, particularly when Samuel asked about the heat of the moment. That provocation has to be in the heat of the moment. So in a situation whereby someone, let's say, someone assaults me, and I want to, in the process of wanting to like hit the person back, which is going in the normal circumstance, going to be proportionate in that circumstance. So let's say someone like kind of intercepted that my blow or something, and that anger is still there for me that I should have done my own back. So because of that interception or that interference between the both of us, that anger is still there. And I was just looking for like the slightest, what's it called? And the slightest, what was it called? Assault again is going to trigger that provocation from the previous provocation. So the next day, the particular individual just did something very little that in a normal circumstance wouldn't have provoked a reasonable person, but because of the anger that I had from the previous conversation I had with the previous day, that anger just like came up within me and I hit the person. Would I still be covered by provocation or defense of provocation or not?
Yes. There is some argument that the law should allow cumulative provocative acts. Okay? Cumulative provocative acts. And this will appear to cover what you have just said now. The guy did a wrongful act or insult the previous day, and then that passed. Okay? He did a wrongful act or insult, and that passed. And which will have justified you reacting at a particular level. And somehow for whatever reason, maybe you tried to respond, you couldn't achieve your response, or you didn't respond at all. And then the following day, he now did something again, which kind of, makes you to remember the injury of yesterday. Now, some arguments have been made that that should be sufficient to allow for cumulative provocative acts. But the jurisprudence on that is not very clear. Okay, and when we get to the defense of provocation, to the plea of provocation as a defense to a charge of murder, we'll look at that issue more closely. So let's keep the gunpowder dry until when we get to that. Okay?
So my second question is that as an individual, like a person, I really do not like, I hate lies. Like I hate when to me, even when you did something wrong to me and I ask you the truth, just tell me, okay, this is it. I easily forgive people. So this guy stole something that was kept in my possession. And I sensed that he did it, like he stole that thing because of like some prior things he has done to other people. But I asked him one-on-one, did you have this particular thing? He said no. Like, did someone give you this particular thing? He said no. I was like, okay. Then before I asked him, I had searched his bag. Then I found that thing, and that was what prompted me to ask that particular question, the questions I asked him. So, well, it was in the night actually. So he wanted to now leave the house, wanted to leave the house after he had taken that thing in his bag. So I called him because the rush by which he went out was so much. So I called him to ask him the last time, okay, guy, this thing that I'm looking for, did you by any means come across it, or did you help me to find? He said he does not have that thing and it's not in his bag. So because I had searched his bag earlier, I now held him by the hand and let's go to this particular place to just let me show you something. So by the time I dipped my hand into where I earlier saw the thing, the only thing that came up was the bag containing that thing. So I was like, oh, this thing is no longer there. Then I asked him to open his bag, which he did. And I saw those things in his bag. So I was so hungry that because I really do not like to use physical stuff, but I really don't have to like to use like punches and the like. So I was looking for like a cane or something because the guy was kind of younger to me, but not so young, much younger. So I was looking for cane. So when I did not, I couldn't find cane, and I had to like engage him like in a physical like punch because I was so furious. And as a result of that, I gave him a cut on his lips. It was recent. In fact, I had to like write on my status that this night I lost my anger for me to be that angry because I really do not get angry easily. So in that circumstance, I think taking my thing, which caused me some kind of provocation, was like my responding in that way, punching him, cutting him a cut. The way it appears to me, it's like maybe can we say that is proportional or not?
Well, it depends on the extent of the cut. If it is just a slight cut, then we can say it's proportional. It depends on the extent of the cut.
Oh,
was it a very heavy punch, or it's just a slap?
It was heavy for me. It was heavy, but the consequence was not something big, just like a cut. That should probably because he hit.
But actually, the scenario you have painted is enough to constitute any wrongful act or insult. Okay, and then the question then would be, how proportionate was your response? So that the circumstances you have painted, in my mind, should constitute a wrongful act or insult. Yeah. All right. So I will take. I think we should move over now to questions on attempt. Adelaja Pelumi. Please, once you have asked your own questions, bring down your hand so that we know the people who are still remaining. Adelaja Pelumi.
Thank you, sir. So my question is on the requirement of insult. In a scenario where two people
I said we should move to, as the last one on that, then we'll move to attempt. Yes.
Okay.
Go ahead.
Okay. So in a scenario where two people are in a kitchen and one person insults the other, maybe calls him an ugly beast and a delinquent stout, and then there are pots and there's a frying pan there, and the other person that was insulted starts like pushing things over and mistakenly now splashes the hot oil on fire on the person that insulted him. Can we say that is proportionate in that scenario?
You use the word mistakenly. All right. I was expecting that you are going to say that he now took the hot oil and poured it on him in anger, or carried a burning stove and with kerosene and threw it on the person who provoked him. As it happened in one case, somebody was provoked and they carried a burning stove with kerosene and threw it on the person who provoked him. And because of the kerosene, the thing exploded and the victim got burnt and died. So the charge was murder because the response was I cannot remember exactly what was precisely the provocative insult, but the court held that the response was out of proportion to the alleged wrongful act or insult. Okay, Balaji, on mute. Balaji, Boluwatife, on mute. Okay, maybe Balaji is not ready to unmute. Oh. Agu Pascal, on mute. Agu Pascal.
Yeah, hello, sir.
Yeah,
good morning. Good morning.
Yeah.
My question borders mostly on provocation, especially when you brought it up. You brought up a point on continuous provocation and most scholars and experts making a case for it. So what I want to ask is relating to bullying. In a case of continuous and extreme bullying, I'm giving an instance of this movie. I don't know if most of you are watching 13 Reasons Why, or like some other instances of like very extreme bullying that becomes very physical, results into amounts to gun abuse or gun violence, or in attempts to threaten the person or stuff like that. And the person has been quiet continuously for a long period of time up until it gets to a stage where, and I'm talking about in a situation or in a climate where guns are legalized, and the person brings a gun to school, and automatically the person starts bullying again. And these are two people who have firearms, who have registered firearms, and bullying starts. And all of a sudden, the person sees the person bringing out the firearm. And this is something that has happened before consistently, threatening the person with the firearm and everything. And the person sees the person bringing out the firearm and he brings out his and he shoots on the leg. That injury leads to the person losing their chances of becoming an athlete in future, leads to emotional harm, leads to etc. And the person is deciding to file charges or everything. So I want to understand the context in which provocation can play a role here, and what exactly will be the remedies available to both parties.
Well, the kind of scenario you painted, it must involve somebody, the person who is bullying the other. One must be the aggressor and the other one must be the victim. So I assume that it was the person who was usually the victim of the bullying that brought out a gun and shot at the other person. Now the first question then would be, is shooting at the victim the reasonable response to the act of bullying in that circumstance? The answer will appear to be no. The answer will appear to be no. If you are being bullied, you can report to the authorities, you can report to the police. But bringing out a gun in response to bullying, in my mind, and shooting somebody on the leg, to me appears to be greatly disproportionate to the act of bullying. Okay? If in the course of the bullying session, the aggressive one who is bullying the other brings out the gun and is trying to use the gun as a weapon in furtherance of his bullying, then if that creates in the victim a reasonable apprehension of death or grievous bodily harm, then he can bring out his gun and maybe shoot at the other. But that must be in circumstance in which there's a reasonable apprehension of death or grievous bodily harm, in which case you will have a plea of self-defense and we will no longer be talking about provocation. So it all depends on the circumstances. But in my mind, it will appear as if bullying there is clearly out of proportion. Ayomide Odubonojo Kinoshi. So let's go to attempts now. Attempts, questions on attempts. If you have questions on attempt, you can raise up your hand.
Good morning, sir.
How
Thank you very much, sir, for the videos. So when I was watching the video on law of attempt, so one question was in my mind, and it was, So during the preliminary preparations, a person states that okay, they want to commit this crime, or or they create a memorandum of their motivations to commit this crime. In the instance where they are caught before they are able to commit, before the commission of the crime, would it hold that they were about to commit the crime, or would it be said that it was just like preliminary? They were only just preparing for defense, and then they didn't have enough, like that, and there's not enough evidence to prove that they were actually going to commit the offense. Thank you, sir.
Yeah, thank you very much. Now, it depends on the facts of the case. Remember, what you need to remember are the guiding principles, the legal elements of the offense. The first one is intent to commit a crime. The person must intend to commit a crime. Okay? Then, in addition to that, he must begin to take steps, commencement of action. He must begin to take steps towards actualizing his intention. In fact, in most cases, without taking steps, you may not even be able to know what his intentions are. Okay, now, once he begins to take steps towards actualizing his intention, he begins to prepare to commit the offense. But those preparations are actually not enough. Like in the scenario that I gave of the person trying to assassinate the president. It forms an intention to assassinate the president. At that level, it's a mere intention. In his mind, you will know, I mean, that's an intention in his mind. There's no way anybody, as I'm sitting here now, you don't know if I've made up my mind to travel to America and go and assassinate the president-elect of America. You will not know because it's in my mind. Now I begin to take steps, like in that scenario I gave. He began to take steps after making up his mind that he wants to assassinate the president. He begins to take steps. He goes to buy a gun and he gets a license. Even at that stage, you won't know what he wants to do with the gun. Now he enrolls in a gun shooting practice facility where he will learn how to shoot the gun. And then he begins to learn how to shoot. And then he perfects his art of shooting over a period of 3 months. Even then, you won't know what he intends to do with the gun. And then, assuming you are watching him in a video, and you see him, going around the office, the road, accessing the presidential office. Even at that point, you may still not know what his intentions are. And then you see him on one day, he climbs a tree, you will still be wondering, what is this guy trying to do? So up all through the preparatory stages, where he has not manifested his intention by means adapted to its fulfillment, in the language of the criminal code now, he must have put his intention into execution by means adapted to its fulfillment. At that point, it becomes clear what his intentions are. But then, he must not have gone as far as completing the main offense. Like in the example I also gave in the scenario. The guy now climbs the tree, overlooking the road that the president will drive through on his way to the office. And on that fateful day, the president, unknown to him, had traveled. So they were just sending the president's usual convoy to go and wait for him in the office. And then from the office, when he returns from his journey, the vehicle will go and pick him at the airport. So he probably thought the president was in the car. He climbs up and he fires several shots at the presidential car at the rear window where the president would normally be seated. Now, at that point, he has manifested his intention by means adapted to its fulfillment. And he has just fallen short of fulfilling his intention because the president was not there. So at that point, that is the point at which we can say that he has attempted to kill the president. So anything before that, there's no offense of attempt. At that point, he commits the offense of attempt. But assuming he shoots at the president and the president was at the back of the car and the president is hit by the bullet and the president dies, then he has committed the main offense. At that point, we will no longer be talking about an attempt. So the crucial point is, at what point can we say that this defendant has manifested sufficient intention to commit an offense? Not as committed. If he has committed the offense, then we are no longer talking about an attempt. We can only be talking about attempt where he has just fallen short of committing the main offense. So that's the general approach to that. Daniel, Joy, or mute.
Good morning, sir.
Morning, Daniel.
Yes, sir. So my question is this: what about a scenario when where A and B, they've been worst enemies? So let's say B now travels to a far place to get away from A, and he has been there for a few years. But then one night B receives a call from A saying that, I know where you live. I'm going to kill you. I'm going to kill you, and all those threatening phone calls. Then the next day, B now receives a letter that was slipped under his door. He opened the letter and saw that A signed it and wrote that, I'm going to kill you. Watch your back. Would we say that, oh, that's attempted murder? I don't know.
No. That's just a mere threat.
Okay.
And I think there's a section in the criminal code that criminalizing threatening to harm the person. Yes, there's a section that criminalizes threatening when you threaten to harm a person. It's not an attempt at all.
Okay, thank you, sir.
Yeah. Abi Bonodiboy, on mute.
Okay, thank you, sir. Can you hear me?
I can hear you loud and clear.
Okay, I have two questions again. So the first one is that in a situation whereby, let's say, okay, particular scenario you painted about the president and the other guy. So where the person aims at the president and the president got really injured, obviously the bullet is going to penetrate into the body of the president, and due to, let's say, quick assistance from people and the convoy and how the bullet was removed and the president received some level of care. So after, like, let's say a week or 2 weeks, the president died because of that, because of the pain, the continuance of the pain from the shot. Will the individual still be liable for the offense? Now
you are asking a question beyond attempt. You are asking a question that relates to causation in homicide cases. Causation. Whether the chain of causation is still continuing from the moment the gun was fired. So I will not answer that question because wait until I think that's an offense. I can't even remember whether it's this semester or next semester. But wait when we get there. It will be exhaustively discussed.
Okay.
So we're only focused on the law of attempts now. Right. I can still see Adela Jakpelumi. Do you still have a question before I go to Adebayo? Adela Jakpelumi, on mute if you have a question. If you don't have a question, then bring down your hand. Okay. Adebayo Rokib, you can unmute now.
Good morning, sir.
How are you doing?
I'm fine, sir. Yeah, this question, I was supposed to ask this question last week, but you promised to answer it today. The question is on...
Did I make such a promise?
Yes.
Yes, go ahead.
Yeah, the question is on immaturity.
Yeah.
So someone asked that, can the parents of a child be vicariously liable for the crime of their child? And you said no, unless they instigate it.
Yes.
Now, my question is that must the act of instigating it, must it be that the parent has ordered the child to do that act to commit that crime, or whether the act of instigating could be by conduct in a way that the child, it just affects the child's mental state. So in the situation whereby a child commits a crime and it was later realized that the parents are violent, and for instance, maybe the father beats the mother every time in the presence of the child, and can we say that the child's action has been instigated by the parents for imposing the negative impression on the child, for embracing violence, which could have...
No, the answer to the second one is no. Now, the first one, if the parent instigated the crime, for instance, the parent asked the child to go to a shop and go and steal and bring food from the shop, or go and steal somebody's money, knowing that the child is under the age of criminal responsibility, they will be liable. Okay, so instigation is when you encourage, when you counsel, or when you procure somebody to go and commit an offense. Okay, then you'll be liable. And if the person is, in this case, is a minor who is not criminal, the people who procured him to commit the offense are responsible, and they will charge for the offense. Mujidat Olanrewaju, you can unmute. Mujidat Olanrewaju, I've enabled you to unmute.
Hello. Good morning,
Yes,
sir. Can you hear me?
I can hear you loud and clear.
Okay, thank you, sir. So my question is regarding the idea of not criminalizing preparation to commit an offense. So we see that, okay, on a general slate, you're not meant to actually criminalize preparing to commit an offense. However, there are certain offenses that could be criminalized, like just based on preparation, like forgery and every other thing. So I want to understand the thin line, like what are the basic determinants. I know that you made mention of a particular test, I think proximity test, but from the video you made mention that it's kind of vague. So what are your suggestions or recommendations on understanding the proper steps to take to determine whether we can criminalize preparation to commit an offense? Like which of what are the basic determinants, sir? That's like the major question, sir.
Okay, now the test of at what stage an attempt, the offense of an attempt is complete, depends on the way the court construed the circumstances of the case vis-a-vis the legal provisions. Now, what are the legal provisions? One, the offender must intend to commit an offense. Then, the offender is required to have taken steps towards the commission of the offense, taking preparatory steps towards the commission of the offense. And in addition to those preparatory steps, he must have manifested intention, according to the wording of the criminal code, by means adapted to its fulfillment. In other words, he must have gone beyond a stage of mere intention. He must have gone beyond the stage of mere preparation. He must have manifested his intention to such an extent that will be clear in our mind that this guy intends to commit an offense. And then, like I said, some tests have been propounded to assist the court in determining whether the point of attempt has been reached. There's a proximity test, which talks about acts remotely leading to the commission of an offense are not what we are looking for, but we are looking for acts immediately connected with the commission of an offense. And then we also have the equivocality test, I mean, the test suggested by Turner, and so on and so forth. Now, the important thing is that all these tests are a guide, but the court will look at the fact of the case and come to a determination that, look, from the facts of this case, it is clear that this guy wants to commit an offense. Like the case of a guy who approached a stack of corn and wanted to set the stack of corn on fire. Nobody will know that that was his intention until he brought out a match, strike the match, was about throwing the now lit match, to set the corn ablaze. He now saw that there were people around seeing him, and then he now stopped at that point. At that point, it was clear that it was not as if he put a cigarette in his mouth, and he struck a match and tried to light the cigarette. No, he moved near a stack of corn and struck his match, wanting to set them ablaze. So it's always all those tests that have been propounded. Yes, they may be useful in their own right, but they are not perfect. So the court is a final arbiter to determine whether in the circumstance of this case, an attempt has been reached. We can confidently say that this guy attempted to commit an offense and therefore, should be held responsible. So there is none of these tests that is perfect. They are just there as a tool to guide the court to come to a determination on the facts of the particular case, whether the offender can be said to have attempted the commission of an offense. But Luby, your answer is still up. Do you still have a question? I've enabled you to unmute. But Luby, do you still have a question?
Sorry, it was a mistake. Sorry.
It's not a mistake. You forgot to bring it down. Just bring down your hand. All right. So, do we still have any question on the law of attempts? All right. Igedoza or Sarihe Joy. All right. To Igedoza.
Good morning, sir.
Morning, no.
Sir, please, my question is not on the law of attempt. I'm sorry to take you back. It's on compulsion, sir.
Go ahead.
Thank you, sir. So I stated when you were teaching that under the criminal code and the penal code that the defense of compulsion is not applicable to a person who brings himself to a state of compulsion. So please, I would like you to throw more light on that, sir.
Okay. Now, let's say that you join a secret society. Don't join a secret society. Just saying it as a scenario. Let's assume a person, okay, let me use another person, so don't let me use you. A person joins a secret society, and he knows that in that secret society, at some point, you will get all the connections in the world. They will link you with the people in power. You will get contracts. You do all kinds of things. But at some point, you will be asked to kill somebody as a sacrifice to the god of the secret society. And you join that society. You have been enjoying the benefit. They gave you a contract of 1 billion in Ajaokuta. They gave you big contracts in NNPC. You are making money. You are enjoying life. You became a big boy. And then your time of contributing bloodshed to the society came. And they gave you a gun. That you are going to kill somebody. And when you kill that person, just take a little drop of blood from him and bring it to the secret society's meeting so that they can use it to sacrifice to the god of the society. Now, you cannot claim that you are forced to go and kill somebody because you are the one that brought yourself under that compulsion, under the situation that created the compulsion. Okay? In fact, there is actually, if you want to read a case on that, you can read the case of R against Obodo. R against Obodo, O-B-O-D-O, 1959, 4 FSC at page 1. R against Obodo, O-B-O-D-O, 1959, 4 Federal Supreme Court cases. 4 FSC at page 1. It illustrates that point very clearly. Okay? Igedoza.
Yes, sir. Thank you, sir.
You can mute back and bring down your hand.
So sorry, can I ask a further question?
Yes, you can.
Okay. So this question is on the law of attempt. So, sir, in a scenario where a person tries to kidnap another, and in the whole process of say he stops a person on the road with his car, then collects the car and puts the owner of the car underneath the car and is driving away. the intention to kidnap, and in the process he's caught by the police. In that situation, and he's then charged with the offense of kidnapping. In that situation, can he plead the lesser offense of attempted kidnapping, sir?
No, the moment he apprehends the person and begins to take the person away, the offense is complete. The moment he overpowers the person, maybe he overpowers him in Unilag, and he wants to take him to Ibadan. And when they go to redemption camp, the police ask him, at a police checkpoint, they stop the vehicle, and then they ask him to go and open his boot. And they opened his boot. They found the victim there. His mouth has been covered, but they left his nose so that he can breathe. They've tied his legs and his hands. The offense is already complete. The moment he takes over and restrains the person's liberty and begins to take him away, the offense of kidnapping is complete. So he will be charged with kidnapping, not with attempt.
Okay, sir.
Because remember, we said in the law of attempt that the person must not have done all that is necessary for the offense to be completed. If he has done all that is necessary for the offense to be completed, then the offense is no longer an attempt. He must not have manifested his intention to such an extent as to commit the offense. If he has manifested his intention as to such an extent as to commit the offense, then he's no longer liable for attempt, but for the main offense. Okay, Gedoza. Samuel Stephen, on mute. Samuel Stephen.
Hello, sir.
How are you doing?
Okay, sir.
Oh, I'm hearing two people talking. Gedoza, I'll finish with you now. On mute and bring down your hand.
I could not hear you, sir. Thank you very much, sir. I understand now, sir.
You're welcome. On mute and bring down your hand. So, Samuel.
Okay, sir. I have a question on attempt. So first, I want to know, are there any specific offenses that cannot be attempted, or are all offenses potentially, subject to attempt charge?
That is a very lovely thing. Now, you need to note that, we stated that when that an important part of attempt is the intention to commit an offense. Okay? Intention to commit an offense. Now, just give me a minute. Yes, intention to commit an offense. So it means that for there to be an attempt, there must be an intention to commit an offense. So if an offense can only be committed recklessly or negligently, then there may be no attempt to commit such an offense, because the definition of the offense is intending to commit an offense. A person who commits an offense recklessly does not intend to commit an offense. A person who commits an offense negligently does not intend to commit an offense. So attempts may not apply to offenses that can only be committed recklessly or negligently. So that's the answer.
Okay, sir.
Yeah.
The last one. So on impossibility of such attempt, I want to know if a person can be liable for an attempt which is very impossible to complete. Take, for instance, let me say Mr. A is attempting to steal from Mr. B's pocket. Unknown to him, there is nothing left for him to steal. So in that circumstance, since there is nothing to steal from Mr. B's pocket, can Mr. A be held liable for an attempt?
Yes, he can be held liable. It can be, because in the law of attempts, if what you are attempting to do is impossible, is physically impossible to achieve. For instance, if you dip your hand into a pocket and you are trying to steal, and unknown to you, there is nothing for you to steal in that pocket, then you'll be liable. You will be liable. Okay? In the case of R&T, the defendant and the confederates were shown to have tried pickpocket. They were trying to pick some pocket. But there was no evidence that the pocket in question contained anything. They were liable for attempted larceny.
Sir, we barely hear you.
Well, I'll repeat myself. I mean, that must be.
Yes.
So can you hear me now?
Your voice is faint, sir.
Okay, that must be the internet. So can you hear me now?
Yes, sir.
Okay. I said that in R against King, the defendant and his confederates, they were trying to steal from some pocket. But there was no evidence that the pockets in question contained anything. They were convicted for attempted larceny. In another case, R versus Bailey and Easterbrook, the defendant broke a box, hoping to steal from it. The box contained some items which were useless to the defendant. So they returned the box and its content. Their conviction for attempting to steal the content of the box was upheld. So because, and the rationale is not so difficult to understand. The guy has an intent to steal. He begins to make preparation to carry out his intention. He has manifested his intention by means adapted to its fulfillment. In fact, the only reason why he's not able to steal is because of physical impossibility. It's because of circumstances. So because of that, the law holds him responsible for attempt, even though he could not have succeeded in attempting to steal. It's also just like the case of Ira White, somebody who tried to kill his mother by poisoning her drink. But the quantity of poison he put in the drink was not sufficient to kill the mother. So the mother survived. He was convicted of attempted murder. So the law is very clear. Once you have an intention to commit an offense, you begin to put your intention into execution by means adapted to its fulfillment. Then at that point, once it becomes clear that you intended to commit an offense, if the offense was in fact impossible to commit, it will be immaterial because we have sufficient evidence to hold you responsible for the offense of attempt. And you'll be liable. The one that creates problem is the case of legal impossibility, where your inability to complete the commission of the offense is because it is legally impossible. And the example I gave in the video is I lost my iPhone. And because I didn't have money to buy another iPhone, I was looking for an iPhone to steal. And in a public place, somebody left his iPhone carelessly, and I picked it. And as I picked it, unfortunately, it fell from my hand, and I was apprehended for attempting to steal it. Now, ordinarily, those facts constitute sufficient evidence of attempt. But if it was later discovered that the iPhone I was intending to steal was actually my stolen iPhone, the person from whom I was trying to steal it was the person who stole it from me. So there's no way I can be liable for intending to steal my own property. Because one of the elements of stealing is that the property stolen or attempted to be stolen must belong to another person, apart from the offender. So if the property is mine, that is a case of legal impossibility. I cannot, there's no way I can, in that circumstance, be found liable for attempting to steal my own property. So that is the only situation in which impossibility, may negate finding the offender liable for attempt. All right. So
the last question.
Yes, go ahead. And that will be
the last question.
Yes.
Okay. The scenario you painted earlier about the guy who wanted to shoot the president. So yes. I want to see from this perspective. Let's assume that this guy had, made the preparations and of course made attempt or the commencement of such acts. And let's say that, of course, the president was to alight in this particular bus station and he has already positioned himself and maybe trying to pull his gun from the pocket. Then a person who sees from behind, attempts to shoot this guy. And so shoots him, maybe a security personnel or anything. But he has a note in his pocket which says that, yes, kiddie, Mr. President, I'll give you maybe a sum of 10 million US dollars. And then when the guy was actually charged for attempted murder of the president, I want to know, in that circumstance whereby he hasn't even, put his gun to shoot at the president, and when he was called upon, he said, yes, someone made an offer, but he changed his mind along the line. But he was only trying to check if the gun in his pocket was still intact or whereas they went ahead and then convicted him for attempted murder. I want to see in that scenario, can anything avail him in that circumstance?
Yeah, you see, if he brings out his gun, if he suddenly brings out his gun in his pocket, and one of the security people, with telescopic devices, maybe on top of a tree or building, watching the entire horizon, suddenly sees him and fires at him, and then maybe injures him, and then they find in his pocket something like you have said, that can add up. That can add up. But if the gun was still in his pocket, then I mean, it will be difficult to sustain a charge of attempt against him. But if he had brought out the gun and was attempting to do as if he was positioning the gun to enable him shoot at the president, then at that point, in combination with the evidence that was found in his pocket, that would be clear evidence that his intention was to kill the president. So it depends on how the court construes the fact. Okay, the last one, I suddenly just saw Bolaji Boluwatife. So that's going to be the last question. Bolaji Boluwatife, yes, go ahead.
All right, sir. Good afternoon, sir. So
Afternoon in the morning.
Sir. Sorry, sir. So
you want the day to end quickly.
So my question is based on the question asked earlier by Ola. So what defense would be available for a doctor who, out of panic, mistakenly takes a liquid which he presumes to be a cooling liquid, but then he finds out that it was actually an acid? So
what will acid be doing in the hospital? You see, our scenarios must be realistic.
No, sir, it was in the past question.
In an hospital, what will an acid be doing? Acid in an hospital, a very lethal and toxic substance. Anyway, go ahead and finish your scenario. Unmute and go ahead and finish your scenario.
Okay, sir. So I saw
there will be something to learn from it. Yes, go ahead.
So I saw the scenario in the past question. So the doctor, out of panic, he presumed that he was taking a cooling liquid from the fridge, but it turned out to be an acid. So I want to ask that, will any defense be available for him since it was a mistake?
Well, maybe a mistake of fact. Maybe a defense of mistake of fact. Because he believed that he was taking a cooling agent from the fridge. And maybe unknown to him, somebody put the acid there. And they put the acid in a similar container where they normally put the cooling agent. So the doctor may be able to raise a defense of mistake of fact. Yes, he may be able to raise a defense of mistake of fact. Okay, thank you, everybody. So I will send the video clip of the lecture on conspiracy and parties. Conspiracy and parties. In fact, I will try and send it now so that you have enough time to listen to it before Thursday, because we only have one day between now and Thursday. So I will send the video clip on conspiracy and parties so that you listen to it very well and be ready for the next class. So if you have not uploaded your matric number and name on the chat box, kindly do so now. And for those of you who are joining on YouTube, you can also indicate. Although it looks as if today, I didn't see anybody on YouTube. There's no indication of anybody in the chat box portion of the YouTube. Okay, so that means yeah, the people who attended only attended on Zoom. Okay, enjoy the rest of your day. I will quickly go and post I'll quickly post it now so that I don't forget. Okay, bye-bye. Enjoy the rest of your day. So I will leave it on for about 2 or 3 minutes. If you have not indicated your name on the chat, please do so now. Bye.